in the fire.
Yeah, man.
Hot pants and back James. The sky's gonna take you higher. Find the keys in trouble. Talk about David. Take your big band master on straight out of here. You gotta just keep.
Hello, everybody, and welcome to Money Talks Media. I'm your host, John Klotz. Welcome to our bi-weekly segment dedicated to growing your money in and around the GTA, and we have a serious roster of speakers, including money managers, portfolio analysts, stock pickers, CRA experts, tax lawyers, accountants, you name it, we got it, all here on Money Talks Media. Money Talks Media is proudly based on the public speaking series Toronto Talks, now in our 9th year as a public speaking venue, and we encourage you to attend our events. Our next event is Tuesday, April 26th, and it features the topic of how to leverage your social media and double your business. This is a must-see for any entrepreneur or anyone out there who's growing their business. In fact, anyone out there who's listening to the show is using social media. So you can check that out at torontotalks.org or torontotalks.com. They all work. And if you're watching the show, you can attend free of charge. Just request that when you confirm on your RSVP. And of course, that is torontotalks.org or .com. And come out and learn how to leverage and grow and double your business using social media. Money Talks Media is sponsored by Northwood Mortgage Life and Partners in Planning Financial Services. You can go to our website and request our newsletter and learn how to take years off the life of your mortgage. And at the same time, we'll show you how to create a very powerful retirement plan for yourself. You can also ask us about our total client experience. So that's all at northwoodmortgagelife.com. You can always call us at the office at 416-969-8130 and extension 230. And again, northwoodmortgagelife.com. If you missed one of our shows, you can check that out at moneytalksmedia.com. And we've got now about 70 shows, all for your viewing pleasure. Of course, you can call in during the show at 416-204-9723. Now, here's our caveat. You're going to be hearing lots of advice today, and it's all free. So always, before acting on anything, speak with your financial advisor, your lawyer, because we are waiving ourselves of any liability. And again, that's our caveat. We have to do that. And especially important today because Money Talks Media today talks wills and estate planning with our good friend, Maureen Tabuchi, and she is a lawyer who specializes in this area. Good day, Maureen. Thanks for coming out.
Hi, John. How are you?
I'm great. We're so thrilled to have you here. And we know that these are important topics, wills and estate planning.
Definitely. Good to be here. I was really looking forward to it. I find amongst the crowd of people, there's the people that get it and the people that don't. If you're listening to the show and you already have a will, you get it. And the rest of the population are going to draft their wills in stages. Maybe when they take that first holiday together without children, maybe when they come upon their 40s, 50s, 60s, and they realize that they're not going to live forever, or maybe into their older years when they get sick and they realize, well, it would be a good idea to have a power of attorney in place, and then the documents are created at that time. So you kind of you can divide the population into the get it and the not quite got it.
Let me ask you something. What percentage of Canadians have wills?
That's a good question, but I think it's an appalling statistic. I think it's something like 20%.
Wow. How many lawyers have wills? I know there's a lot of them who don't. I've met them.
Right?
Yeah.
I guess that would be the case. In fact, probably now if we narrow that down to the lawyers who practice wills and estates planning,
right.
then you may get a better statistic.
No, I'm just saying lawyers in general, of course.
Yeah, on my hit list, and we have a little section in our firm called the Wills Police, and we have a few lawyers on that list, John. So
yes, exactly.
You're definitely right.
Telling everyone what else to do, but not doing it themselves. No, absolutely. No, this is an important topic because you can die without a will. And it's awful. It's awful to die, but there are huge financial implications of not having a will. Maybe you could elaborate on that, and maybe we could talk about what has to happen.
Sure. Let's dispel some of the myths. Their financial implications maybe in extra legal fees.
Yes.
You're not going to find there's no difference in your tax rate, the fact
Right.
that there's a deemed disposition of your assets on death. None of that changes based on whether you have a will or not. But here's the way we like to explain it is you've got a grieving family. Do you want to have that extra burden
Right.
of going through the process of being appointed as an executor, or having the bank say to you, I'm sorry, we can't release that money without a will? So there's a lot of emotional and administrative items to deal with when you die intestate. It's
Right,
called.
and that's and so now, have you experienced some of these as a lawyer? Have people come to you post, a spouse has passed away and suddenly they didn't have a will and
Yeah.
suddenly they're scrambling. What's that been like?
Yeah. Sometimes people don't have a will. Sometimes they lose the will,
Yeah.
misplace the will. The will was with a lawyer who has disappeared off the face of the planet. And a lot of people don't realize this, but there's actually a home for lost wills that the Law Society has created so that lawyers who are no longer in practice, lawyers have guidelines what to do with wills if they leave the practice, or if if the lawyer passes away, then there's certain protocol that has to be followed. What to do with will. So your will's always in a safe place, but if you don't have a will, then that's going to be a problem. In my experience, it's basically an extra application to the court to have somebody who steps forward to be appointed as your executor.
Okay.
So that process runs somewhere around between $500 and $800, and I always figure out, well, it's cheaper to actually do your wills than
deal
to
with that.
have that process, to have the court appoint an appropriate executor.
Okay, so let's talk about some of the things that go into a will.
Okay.
And maybe you can break it down and give our listeners and viewers something that they can talk to their lawyer about, perhaps in looking at this.
Okay, John, this is going to take about 2 seconds, because the problem
Yeah.
with starting to think about what you're going to put into a will
Yes.
is it's overwhelming.
Yes.
Who would be who would be a good executor? Who should I leave my stuff to? People get overwhelmed. And so if you have no children, I need to know, or your lawyer needs to know, who's a good executor. If you're married, it's kind of a no-brainer. Even if you're older, unless your spouse is in the later stages of age, you can have that spouse act as your executor and then have backups. So whereas lawyers used to say, don't appoint someone who's close to your age because they could go before you, but you're going to have 3 or 4 backups in a well-drafted will. So
Okay.
don't worry about that. So number 1, who's a good executor? Number 2, who are you leaving your stuff to? Again, it's usually a no-brainer. Your family is usually the first choice, and often in a typical situation with a family, you're going to leave everything to your spouse. If your spouse has predeceased you, you're going to leave it to your kids. And that's most often in equal shares between the 3 children. So that's it. That's all you need to
That's
do.
all you need
do
to
your
do.
will.
Exactly.
It's
It's
simple.
so simple.
It's so simple. It's not difficult.
I know. So why are people struggling with it? Is it or like, why do people not have a will? Like, what if it's so easy? Why is it like the majority of Canadians don't have one? What do you think that's all about?
Well, I think 2 reasons,
Yeah.
and because people think, and even here's a fault on my website. I have an online form that you can fill out, but on the online form, somehow we got a little carried away, and it says, well, what are your assets? So when people go to fill out this form, they get halfway through the form, and it asks for, what are your investments? Oh man, I don't remember the investment account number. I have to go get that. Life insurance policies, I need those numbers.
Yeah.
No, John, when you're looking at a will, the will deals with the residue of your estate.
Right.
Even someone asked me this morning, well, what if I just sold a property and I have cash and we're not sure what we're going to do with that cash? no need to worry. All of your stuff is going to go into this pot called the residue, and that will be distributed the way you want it to be distributed. And again, if I can add, that's the importance of having a will versus not having a will. It's the way you want it to be distributed.
Right.
Because if you don't have a will, then the intestacy rules apply, and it goes the way the government says it should be distributed.
And maybe you can elaborate on that, because I know I want to ask you a couple of questions. One is, there are certain assets that, as you and I both know, should stay outside of the will.
Yes.
Such as RSPs and life insurance, correct? Maybe you can elaborate on that. But there are, in terms of the will, there are ways to reduce sort of taxation implications on death, and maybe you could elaborate on that as well.
Yes. Here's another real simple phrase. The best will, John, has nothing in it. Okay. Now, this is easy to do. Yeah, so you pay all the money to the lawyers, and then there's nothing in it.
Right.
But here's the thing. Especially when you're dealing with a couple, so there's two of you, whatever assets you have that you hold jointly is going to automatically pass outside of the will. RRSPs, you're going to have a designated beneficiary. Life insurance policy, you're going to have a designated beneficiary, and you can have wording so that there's even a gift over, which a gift over really means if your spouse has passed on, then it goes to a trust for your children. So those are, that covers almost everything. Your house, you could own as joint tenants. So that simple situation doesn't apply for what we call the last to die. So when you're dealing with, like, the first spouse has already died, and then you have the second spouse, then there's other tax planning that you can get into involving trusts, and that's a lot of fun to get into that, because you can save tax money, and it's money that's money that doesn't go to the CRA, it goes to the hands of the family.
Absolutely. I want to ask you about people with children.
Yes.
And let's say, and what do you think are the best ways to deal with minor children with respect to estate planning, and how do you choose the guardians, and how do you choose the executor? Maybe I could throw those questions out at you, and you could sort of elaborate.
Perfect. Let's talk about a situation where the couple they won't come in to do their will because they don't know who would be a good guardian.
Right.
And
I come across that a lot.
Yes.
We don't know.
And they may have even asked somebody, and that somebody said, no,
Exactly.
Just because people are intimidated.
It's
they don't
overwhelming.
think, exactly,
It could be
they don't think they
overwhelming.
would be able to do as good a job as you. It's a big responsibility. Here's the thing. If you die without a will, then somebody has to step forward, or these children are going to be orphans, basically, in the old-fashioned sense of the word. So somebody ultimately is going to step forward. You don't need somebody's permission to put them as a guardian in the will. Again, why not appoint who you think would be most appropriate, have a backup, have a third backup if you want. That person always has the option to say, if, for heaven forbid, the time came around that you and your spouse passed away and this clause kicked into effect to appoint the new guardian, that person always has the option of saying no. And if they do at that time, then you would have a backup or two to rely on. So you don't need their permission. Grandparents are good. A lot of people say, oh, no, I can't appoint the grandparents because they'll pass away before me. Well, you're dealing with minor children, so you only have at most 18 years of living before you wouldn't need to rely on the grandparents anymore. So you think that's basically say anybody is better than not
nobody.
Having a will.
Interesting. So, because I know I come across it as a financial advisor, that people do grapple with this, and we're actually, it's an interesting point that you said. People they say, oh, if we died, my parents would bring up the kids, and the parents are in their 60s and 70s, and I always thought, and I'm glad you're here, that would not be a great beneficiary because they're too old. And, you know, who wants at 65 or 7 to be stuck with a couple of kids? You know, just food for thought. So I find your comments interesting.
Yes, thanks. Here's another good scenario. In fact, it was my own personal situation. We had 4 grandparents, and so you could apply this to the same situation where you have grandparents and maybe siblings, you know, aunts and uncles. And why not appoint all of them and they decide amongst themselves? If it's a friendly situation, you know, now you have to be careful because you don't want to look for, you don't want to be creating problems, but the people that you love are going to be doing the best thing for your children. In my personal situation, we appointed the 4 grandparents together, and they would be able to determine who would be the best guardian for the children.
So they were actually able to decide amongst themselves.
We gave them that power in our will.
Okay, interesting. All right, Money Talks Media has been talking wills and estate planning with our good friend Maureen Tabuchi. We're going to take a brief musical interlude. We'll be back talking wills and estate planning. Thanks.
Thanks, John.